All right, Ms. Hadley, we're up and running. Make sure you tell us the case name, and just the issue in the rule and the conclusion.
Okay, I'll go at like a decent pace so we can write it down. So my case is in Ray adoption of Holland. So the issue in this case is whether the adoption petition should be granted to confer this adult grandson federal aid that would not otherwise be available to him. And then the rule statement is under Florida law, any person, minor or adult, may be adopted, and just noting that adoptions in Florida are statutory based. And then therefore, if an adoptee becomes entitled to a benefit authorized by law, it cannot be said that the adoption is in violation of public policy.
Very good. Great.
I had Mullins versus the state of Oregon. So the issue here was whether or not the biological connection standing alone gives a grandmother a constitutionally protected liberty interest in the adoption of her grandchild. The rules here is that neither the text and the structure of the Constitution has ever supported the asserted interest of a prospective adoptive parent as a child he wishes to adopt. And thus the conclusion that came from this court was that grandparents have no constitutionally protected liberty interest in the adoption of the children's offspring.
Very good.
I had Santosky v. Kramer. The issue in this case is whether process is constitutionally due to a natural parent at a state's TPR proceeding, and if it is, what process is due. The rule is that the state may terminate over parental objection the rights of parents and their natural child upon a finding that the child is permanently neglected. And the New York Family Court Act required that only a fair preponderance of the evidence support that finding. And the court held here that the due process clause of the 14th Amendment demanded more than a preponderance of the evidence standard. So before a state may sever completely and irrevocably the rights of parents and the natural child, due process requires that the state support its allegations by at least a clear and convincing evidence standard.
Very good.
So I had BY grandmother versus Department of Children and Families. The issue here is whether the court can finalize an adoption without the consent of DCF if it's the best interest of the child. And the rule is yes, under Florida statute 63.125, the court can finalize an adoption without the consent of the Department of Children and Families if the court determined that it's in the best interest of the child.
Very good.
I have DCF versus statewide GAL program. So the issue is, can a child court overrule DCF and place a child in an adoptive home without the court finding a reason within the best interest of the child? And the rule is that DCF has the authority to choose what home to place children in and consider the child's best interest. And the court cannot interfere with that unless they have a finding that DCF is unreasonably withholding its consent to an adoption and not acting within the best interest of the child. But the court, in order to do that, the court must have a finding for the best interest of the child to have authority. Otherwise, the court violates the separation of powers of the Florida Constitution. And the ruling was they agreed with DCF and overturned it.
I had Burns v. Crenshaw.
What was your case again? No, it's your.
Mine on Burns v. Crenshaw.
Okay, I just wanted to make sure everyone heard that because I know this was on there.
The issue is whether the plaintiff was entitled to notice under the Oregon adoption proceedings, and the rule stated that to provide notice owed to future fathers who had been involved with children or had filed with the registry was not arbitrary and does not deprive the future father of due process.
So your case says that notice wise, if you're not in the PFR, you don't get notice. Yeah.
I had in-right adoption of BY, and the issue was whether or not the father was owed due process, even though he did not file himself with GIVR, believing the mother's request that she would not put the baby up for adoption. And the rule is that fraudulent representation is not the excuse for failure to strictly comply.
So if a birth mother defrauds you, lies to the father, too bad. He's out still. That happens. We talked about a case I had. The birth mother told biological dad she had an abortion. She didn't. He doesn't get noticed, getting the PFR, even if you're lied to, even if you're defrauded. So we need to make sure we understand the concept, because it comes up multiple times in the exam. And it doesn't matter. The only person that can't defraud the parents is the attorney or adoption agency. Moms, all you, yeah, they're good. They can do whatever they'd like.
My case was in her adoption of baby boy Brooks. The issue is whether the father waived his right to consent to the adoption of his biological son when he failed to register with the PFR within 30 days of birth, even though he was already judicially established as a father. And the rule is that consent of adjudicated father is required for adoption, even if he failed to register with the PFR. And when parental consent is withheld, when parental consent for adoption is required and then denied, a probate court cannot approve adoption based on the best interest of the child.
Okay, so now this case is different, okay? What makes this case different is this guy wasn't in the PFR, but he had a paternity decree. Okay, that's the difference here, okay? So you gotta be one of those 5 people that's in your rule statement that consent is required of. You just gotta be one of the 5. You don't have to be in the PFR if you're one of the others. So example, I am married to, well, obviously I'm married to my wife. So I am married to a female, to this female lady, her name is Susie, right? And we conceived a child. Okay? And she goes to the hospital, gives birth to the child, and wants to give the child up for adoption. I'm not in the PFR. I don't need to be in the PFR because I'm a legal father. Because I was married to her at the point of conception, okay? Now, I'm not married to her. I don't have an adoption decree. I don't have any of those papers, right? I'm not on the birth certificate. I don't have any of that. Then I have to be in the PFR. So that's kind of the construct there on that case. You don't always have to be in the PFR if you're one of the legal fathers.
My case was Hybrider v. Carden. The issue was whether a father that failed to register with the PFR within 30 days of the birth of the child and had not had paternity established had a right to a notice and consent in the adoption proceeding. The rule is no, the future father is barred thereafter from bringing or maintaining an action to assert any interest in the child during the adoption proceeding. It is considered to have waived and surrendered any right to notice of any hearing in any judicial proceeding for adoption of the child, and consent of the person to the adoption of the child is not required, and the child is considered to have been abandoned since has been abandoned.
Once again, you're not in the PFR, you're out. Now, but this case, the reason we did this case, why it's in there, is it's talking about 30 days. That was that state's law, okay? 30 days after birth, okay? Florida law is not 30 days, okay? Florida law, there is no day requirement. It is when the attorney files the termination of parental rights petition, whenever that is. And I can tell you, it's fast. I have it out within 48 hours from birth. That's the moment. Matter of fact, I have 2 babies that are going to be born in the next 2 weeks. Okay, we have 2 due the first week of December. The term of parental rights petitions are already drafted. They're already uploaded to my file system. All I have to do is hit the button. Okay, that is Florida's law. The moment the TPR is filed, you got to be in the PFR. So what I got to do is I got to check the PFR before I hit the button. Okay, so I checked the PFR. Remember I just said 48 hours? That's because I gotta wait 48 hours to get consent from the mom. Okay, so that's why it takes 48 hours. So 48 hours, I get consent of the mom, checking the PFR, nobody's in it, hit the button. And so.
I have Department of Health and Rehabilitation Services versus that. The issue in this case is whether HRS can require a putative father to submit to blood tests if the legal father and GAL have not been heard or given notice. And if so, what factor would be alleged in the complaint? And the rule here was a trial court hearing a petition for a blood test is required to determine that the complaint is seemingly accurate, actually brought in good faith, likely to be supported by reliable evidence, and likely to find that the child's best interest will be better served, even if the blood test later proves the child is co-deceased.
Okay, so just because you're bio dad, you don't win. Isn't that crazy? So the case stands for, okay, I'm married to Susie. Susie cheats on me with Joe. Joe is actually the biological father. I'm the legal father. Joe files for a paternity action and for genetic testing. And Joe is found to be bio dad. That doesn't mean he wins. The court still decides, is it in the best interest of the child for me to be the father or for Joe to be the father? Crazy stuff, this adoption.
I had Simmons v. Perkins. The issue here is whether the common law presumption of legitimacy creates an absolute bar to an action by the biological father to establish paternal rights, or parental rights, when the child was born to an intact marriage and both husband and wife object. So then the court ruled, no, the presumption of legitimacy is intentionally very strong, but a biological father may overcome this presumption and establish his paternal rights when he shows a substantial and continuing concern for the welfare of the child and can establish by clear and convincing evidence that replacing the mother's husband as legal father would promote the child's best interest.
Interesting. So he has the burden. What just was said was, yes. I forget what I call this guy over here, Bob. He can file this action for paternity, but he has to show by clear and convincing evidence, not preponderance, clear and convincing, the same standard that we just talked about way over here, that if we're going to terminate someone's parental rights, DCF has to show it by clear and convincing evidence. It's a very, very high standard. Same thing over here. The guy that's the actual biological father, it's his duty to show that he is a better fit, it's in the best interest of the child by clear and convincing evidence. Once again, bio dad, not a lot of rights here. That's the theme of the class. Is at the end of the day, you don't have a whole lot of power if you're not a legal father. If you're not one of those 5 people on the list that's required, you don't have a lot of rights. There's only 5 people rights. Everybody else, uphill battle.
I'm Henry Small, British Department of Children and Family Services and Kids with Life Adoption. In the case over the legal father's objection, the adoption agency tried to terminate his parental rights and go forward with a family adoption to the aunt and uncle via biological father. This was the legal father due to intact marriage at the time. And he petitioned the court to keep his parental rights, and he was taking part in the commission and everything like that. The court held that the presumption that he is the father because he was part of an intact marriage makes him the legal father, and they can't overcome that, but he is to consent and notice before there's an adoption.
Yeah, he gets rights, even though he's not the bio dad, he's a legal dad. So they gotta get his consent, okay? They gotta give that guy notice. But the actual biological father, he doesn't have to get anything. Crazy. Next case.
I had Department of Revenue versus Cummings. The issue is whether legal fathers are always indispensable parties in a support action for paternity brought by Department of Revenue. Quick background is these were 6 consolidated cases. The mother was married to a man other than the alleged putative bio-father at the time of the child's birth, and the DOR filed complaints on behalf of the mother against the putative bio-fathers without including the legal father. And the court found that the legal father of the child is always an indispensable party in an action to determine paternity and support obligations.
Once again,
Essentially,
no, you're good.
essentially, it's just saying that a bio dad is not off the hook. Even
Right.
though there's not putative.
Correct. So interesting, think about this for just 1 second. You get all the rights and all the responsibilities as a legal father. That's what the case stands for. So I'm married to my wife, she cheats on me with Joe. Joe's the bio dad, I'm the legal dad. I'm on the hook for child support over here. Okay? Until paternity is established somewhere else, it's me. Now, they gotta get consent before they can do an adoption, they gotta do all these things. I get all the rights as a legal father. And guess what? I also get all the responsibilities. All right, next up.
I had IV versus CES. This was the maternal grandmother wanted to file CPR on the mom, and the adoptive parents would then be the grandmother and the father. It was whether a father who already had a legal relationship with the child can be a petitioner in an adoption petition. Court said no, because he already has a legal relationship with the child. And the adoption, granting the adoption would basically terminate his legal rights.
Very good.
I had in the adoption of we never learned how to pronounce it. Like
With a Z?
Sash, yeah.
Yeah, the Z.
Yeah, it's it was a really complicated case. There was a lot going on, but essentially the bio dad, when he consented, he added a clause to the consent that isn't part of the statute, and then at the same time, the lady trying to adopt the child, she moved against him to try to get the child, because she had had the child for 30 days by the time she filed the petition, so she was trying to use that time towards her time spent with the child. And it went back and forth, eventually made it to the Supreme Court. And it was determined that the father's due process rights were not violated because it followed the statute. It determined that nobody's rights were violated. Essentially, the lesson was that the statute has to be construed. They can't just make a clause just because they want to have that clause.
Right. The issue in Ray Z is pretty simple. I mean, it's exactly what you said. The issue is, it goes back to, all the way back to, when Hadley gave her, case brief, is adoption is statutory, okay? It's statutory, so it's the same thing as Hadley's, the same, it's statutory. And what your case says that goes above and beyond that is it has to be strictly complied with. So either it's in the statute or it's not. If it's not in the statute, it doesn't exist. And basically what the court, and that's what the court found, is that strict compliance of the statute is required. No substantial compliance, no I kind of complied, strict compliance. Miss a comma, you're out. Okay, exactly what it says, it's what has to be in there. Don't add it to the statute. There is no common law, no. Chapter 63, read it, if it's in there, you can put it in your consent. If it isn't, you can't. So.
Okay, I had Stanley v. Illinois. Basically, the mother dies here and the father was trying to gain custody of all the children. So the issue here is, may the court state deprive an unmarried father of custody of his children solely based on his children's legitimacy. The rule that came from this is unwed fathers have a right to notice and a hearing and a termination of parental rights. So the whole thing, as well as the presumption of unwed fathers are unfit to have custody of their children, violates their due process rights and also violates the equal protection. And also likewise, like fathers, married and unwed mothers, unmarried fathers are entitled to the same rights of a hearing as the fitness of others.
Interesting backdrop on this case. So we kind of understand where this one's at, is there was a presumption in different states that you weren't fit to be a father if you didn't marry the mom. Okay, so hypo goes, I'm with Susie and we're dating and we conceive a child together. Child is born. We never get married, but she puts me on the birth certificate. We live together. I act as a father. I'm great to her. Everything is fine, but I never marry her, okay? Well, many moons ago, people felt in our legislatures that I wasn't a good person because I didn't marry her. And they said, you're not fit to be a father because you didn't marry, you're not seeking permanency in this family unit because you didn't marry her. Because you can just walk out at any time, really easy. So you're not really committed to this family because you didn't marry her, okay? That was the concept back then. So now this girl that I've been living with and had a child with, and everything, she got, under the old law, I couldn't adopt a kid. I mean, it wasn't my kid. They put the kids up for adoption. DCF comes in, takes the child, and says, if you wanted to protect your rights as a father, you would have married her. Now, that is not the law anymore. Thank you. Well, whatever you believe on that is what it is. It's not the law anymore. And that's what the case stands for. Just because you didn't marry her doesn't mean you're an unfit father. Ms. Aaron, you have it.
Yvonne versus Mohammed, so the issue is the difference between the rights of unwed fathers compared to other parents violate the Equal Protection Act or Equal Protection Clause of the 14th Amendment if the discrimination is involves the state's interest. And the rule is the gender of the parents do not matter to the state's interest. A parent, regardless of gender, will have equal rights to parent their children. And the court conclusion was the state does not have a viable interest in discriminating against fathers after the child is a newborn. Or violates the Equal Protection Clause, terminates unmarried biological father's right to parent when he's been acting.
Many moons ago, we felt that men were not fit to be parents, or not as fit. I shouldn't say fit to be parents. We're not as fit to be parents. Whether you believe that to be true or not, that's your own personal preference. But either way, the law says that we're all equal under the 14th Amendment. And so like when you're doing family law, okay? So any of y'all that want to be family law attorneys, God bless you. And your addictions. But what happens is when you go to court, okay? In the old days, it would be presumed that the female, okay, would get the majority of the time sharing to raise the children. Okay? And the man wouldn't. Okay? They would get like every other weekend kind of thing. Yeah, Wednesday nights and every other weekend. I mean, and this isn't that long ago, people, FYI, okay? But we've changed that. And now when you're a family law attorney and you walk into the court starts with 50-50 time sharing for each person. And it doesn't matter what your gender is, it doesn't matter any of that kind of stuff. We start at 50-50. Now, can a judge deviate for that with cause? Sure, they can. But I can tell you from someone that just in general has an office that does family law. I don't do it anymore, but an office that does all the time. Yeah, it's pretty much 50-50. To deviate from it, normally it means because one of the parties actually wants to deviate from it. Like they're good with it. Not even that they want to, but my last family law case that I actually went to court on, that's what it was. I represented the father, and his whole thing was, you know, I want the kids just to sleep in the same house during school. He's real safe with mom. Everything's great. You know, I love my child. So I'd love to have my child every other weekend. And when school's not in, I'd like to have spring break. I'd like to have extra time in the summer. But I don't want to disrupt the child's life going back and forth house to house. That's not good for the child. And it was his choice. So it worked out in that case. But if he would have walked in and said, no, I want the same amount of overnights as her, he gets it. But before, we had due process issues. Next case.
Okay, so I have Ware v. Robertson.
This is an important case.
Yeah, so
This is my favorite case in the whole class.
This case stands for constitutionality of a PFR. So the issue is, does the due process clause require notice of an adoption proceeding to be given to a biological father who may be an interested party to the proceeding? And the rule basically is that the due process clause does not require notice of an adoption proceeding to be given to the bio father. I have also written down that there are rights afforded to fathers in their children's lives, and parents get rights who have been involved in their children's lives. Since the father was supposed to file a PFR and he didn't, that's his own choice, and therefore he doesn't get due process, basically.
This is the case. You can guarantee this is on the exam. This is the biggest case. This is the United States Supreme Court case. This is the whole case. Is 80% of what we talk about is honestly this case. This is the case that says the PFR is constitutional. That's what this case says, is that is your notice, buddy. You need to be in it, whatever the state's rules are. If you're in it, you get notice. If you're not in it, you don't. And the argument before the court was, well, no one even knows about it. And the Supreme Court was like, well, then tell us a better way to do it. Because no one's come up with a better way. There just isn't a better way. So we have this registry, and if you're not in it, you're out. And it is the case that, like when I go to court and there's a putative father, or I'm just talking to a judge, there he Robson. Judge, it's binding on you. It's the United States Supreme Court. Says PFR, either you're in it or you're not. It's cut and dry. There is no kind of. There is no fraud. Oh, the birth mom defrauded. Either you're in it or you're not. There's no other question that needs to be asked when we walk into court. We did one a couple years ago, it was in COVID time, like on Zoom hearings. And the judge, is very, very good at adoption and had done a bunch of them. And the hearing lasted about 30 seconds. So I started, Judge, we're here today. He goes, let me stop you, Mr. Harris. And he looked over at the other guy and he said, did you file in the putative father register? The guy goes, no, I didn't even know what it was. And he goes, well, unfortunately, under Larry v. Robinson and the United States Supreme Court, if you're not in that registry, when Mr. Harris files his termination of parental rights, you lose. And struck me out. That's the way it works. It's cut and dry. Either you are or you're not. Strict compliance and adoption. Either you strictly complied or you didn't. We had one guy that I mailed it in. Like, he might have. He wasn't in the registry though. Maybe it did get lost in the mail. Is it possible? Sure, it's possible. And the problem that he had is it's not like he can check himself to see if he's in it. You can't look at the PFR unless you're an attorney or an adoption agency, or you get a court order. Those are the only three ways you can see it. So he couldn't even check to see if he got in it. Was he in it? Did he actually send the mail? Maybe. But he wasn't in it. He's out. He loses. Sorry, is what it is. I mean, what you guys are gonna learn really, really fast here very, very soon when you're out practicing law is sometimes it isn't fair. Not always the right outcome under fairness comes into play. I mean, it just doesn't. It's an imperfect system. But I will tell you this from someone that practices it day in and day out, it is the best system in the world. But it isn't perfect. Next case.
So I had Michael H. and Victoria D. versus Gerald B. And the issue in this case is whether a statute that prevents a possible biological father from establishing his paternity of a child violates the due process clause of the 14th Amendment, which was no, because under the California Evidence Code 621, it does not violate the due process clause by denying a possible biological father
the chance to establish his paternity of the child after 2 years have passed since the child's birth. And it found that a possible biological father does not have a fundamental right to obtain parental rights after the presumptive father has exercised significant responsibility over the child.
Okay, very good. Next up, you got the Troxville case? Yeah, grandparents don't get rights, third parties don't get rights. So I will say it, I got you. So here's the deal, third parties, mostly grandparents. They don't have rights to notice, hearing, any of that kind of stuff, unless in Florida, the child has lived with a grandparent, not a third party, a grandparent for 6 consecutive months. Okay, that's what it states for. That's what your case is about. Great case. You did a great job last night. I'll do it for you tonight. Next case.
Daniel v. Daniel.
And that's Troxville, by the way, just so you know. Okay, sorry.
Daniel v. Daniel. The issue is whether the presumption of legitimacy is overcome when a married husband and wife stipulate that the child's father is not the husband, but do not challenge the child's legitimacy and the birth certificate remains unchanged. The rule is that under Florida law, a person has no legal duty to provide support for a minor child who is neither his natural nor his adopted child, and for parents' support, he is not contracted. So the court held that the daughter was born during the lawful marriage of the parents, so she was a legitimate child, and her legitimacy would not be affected by a termination.
Right, because you still got a dad. I mean, that's what it's saying. What the case is saying is, we'll go back to my hypo over here. I got my wife, Susie. She's with Bob. Susie comes to me and says, I'm pregnant and I got really bad news for you. You're not the dad. And I'm like, wow, okay. He's the dad and I want to be with him. And I say, you know what? Goodbye. You should. But presumption of legitimacy is I'm the father. What the court's saying here is as long as we got a dad, as long as me and the 2 legal parents are on board here, we can stipulate that this guy getting a genetic test being the dad and be on the birth certificate. Like, I don't have to be the dad. I can waive that, but we gotta figure out who dad is. Okay, next case.
I had JG versus State of Florida, and the issue was pretty much how much time is there for a biological father to move to set aside or nullify the adoption of children by non-relatives. And the ruling says a biological father is barred by statute. That included filing any action or proceeding of any kind to vacate, set aside, or otherwise nullify a judgment of adoption of an underlying judgment terminating parental rights on any ground more than 1 year after entry of judgment terminating rights. And the court held that the biological father lacks standing to challenge adoption.
Okay, so okay. The case is accurate. You have 1 year, okay? But you only have 1 year to appeal a judgment for adoption if you claim fraud or duress. And that fraud or duress has to be on the actions of the adoption agency or the attorney. Okay, so the case is true, you got 1 year. Fraud or duress of the attorney of the adoption agency. You have 30 days to appeal a judgment based upon you believe the judge violated the statute. So you believe judicial error, you have 30 days. You have 1 year fraud or duress on the agency or the attorney. That's that. So your case is accurate because it says you only got 1 year, but that's the little caveat. Next case.
I had in readoption of John Doe versus Richard Rowe and Mary Rowe. The issue is, does an unmarried biological father who does not provide support for a pregnant mother abandon the child by his pre-birth conduct? The rule is pre-birth conduct tends to prove or disprove material facts bearing on abandonment and may be properly introduced and used as a basis for finding abandonment. Parents who have not provided the child with emotional and financial sustenance can be deemed to have abandoned the child. Failure to communicate does not mean a child was abandoned. Unwed women and their children are placed at substantial risk for physical and mental health issues by inadequate nutrition and or healthcare. So the conclusion by the Florida Supreme Court was that it's critical to the well-being of a child that an unwed biological father provide pre-birth support when such support is needed and within his means. Failure to assume parental responsibility is abandonment under layer and is sufficient to deny parental rights.
Pretty simple. If you're not paying, you abandon before the child's even born. You've abandoned. And the statute says you can abandon it, if you don't provide financial and emotional support, you've abandoned. That statute's actually incorrect. Because it's actually an or, and well, the courts have made it an or. Okay, yeah, I mean, the Florida Supreme Court has made it an or. That it says and in the statute, but they believe that the legislative intent was that the statute was actually meant to be written as or. So it's or. So if you don't give money, but you love mom, and you go to Lamaze class, you do whatever. You can still get, you still can have abandoned, or same token, you pay money, but you don't emotionally support. You can have abandoned. Daniel?
My case is in the adoption of baby EAW. The issue is evidence of a parent's pre-birth conduct relevant to whether a parent has abandoned a child, and therefore waive their ability to consent to an adoption. At the time of this case, because Chapter 63 doesn't define abandonment, the court turned to a case in readoption of Doe to determine that a court may consider the conduct of the father toward the child's mother during her pregnancy as indicative of how he abandoned the child. This situation, GWB was very abusive and neglectful to the birth mother of his unborn child and did not provide emotional or financial support to the birth mother. The judge found through clear and convincing evidence that the birth mother was on her own emotionally during the pregnancy and was not supported financially by GWB, who even assumed a sexual relationship with a former girlfriend while the birth mother was pregnant. In addition, the trial court found almost no testimony to establish GWB exhibited any feelings for the unborn child. So the Florida Supreme Court affirmed the trial court's decision and that GWB's consent was not required before baby and the baby could be placed for adoption without his consent.
If you abandon it, you're out. Don't need your consent. Goodbye. Even if you're in the PFR, you've abandoned. And that's kind of where it's getting at. You can have any of these papers, okay? But if you've abandoned the child, they can still TPR you. Now, I'm not testing you on that, but I'm just saying in general, I mean, this stuff gets really, it's very complex in practice, yes.
So like, isn't one of the main reasons somebody would file the PFR is just in case, so but like, how are you just providing anything before, so you can even get to.
Okay, so this is what actually happens in practice. That's a great question. What actually happens, okay, if attorneys and adoption agencies are involved, okay, not just random people kind of thing, but expectant mom comes into our office and says, hey, I want to place my baby for adoption. We do a PFR right then. We actually do it a couple times through the thing because we want to see if someone's in that registry. And if they are, then we have to contact them, what's called a notice of intended adoption plan, and ask them for money and ask them for emotional support. That's what happens when people are involved. Okay, like people are involved, people are always involved. But when agencies and attorneys are involved, they get notice in the PFR. The issue that you're concerned with is when no one is involved, just mom, and she is in the hospital and says, I want to get a baby for adoption. In those instances, he hasn't abandoned because he didn't know that the child needed emotional support or financial support. But what adoption agencies do and adoption attorneys do is check the PFR, because we're hoping someone's in there. But if someone is in there, we can put them on notice that a baby was born to that action and we need money. Keep in mind, I've never had one, but that's why they do it. Next up.
Okay, I'm at Coleman Last Adoption Agency versus DM. There was a lot kind of going on in this case. The main point is that there was ongoing litigation that was happening between the couple, well, the biological father and biological mother. Where the biological father argued that he had not consented to the adoption. And then at the end of the issue, the court said that a chapter 39 dependency proceeding could not be ordered in a chapter 63 termination of parental rights proceeding. BM argued that that meant that he had no obligation to his child until it was remedied. And the court said that the existence of ongoing litigation does not overcome the requirement that the father demonstrate full commitment to the responsibilities of parenthood.
So just because there's litigation going on, just because you're trying to determine this, determine that, because one case is going on over here, you still gotta act like a dad. Yeah. You had 2,
Had 3.
you had 3, good, who's like 4? You do one for Tuesday, I'm just kidding.
I have in the matter of adoption of baby girl B. The issue was, does the UCCJ apply to adoption? The answer is yes. UCCJA, that act applies to custody proceedings. The definition of custody proceedings is broad enough to encompass adoption cases. While the UCCJA does not specifically state that it applies to adoption proceedings, it does apply in a child's custody determination. Most courts have found that the UCCJ applies to adoption. Custody proceedings is defined in the UCCJ to include proceedings in which a custody determination is one of several issues, such as an action for divorce or separation. This definition is broad enough to include adoption proceedings, which inherently determine custody issues.
Very good. Oh, sorry.
Just to say the conclusion of the case, if you want.
No, yes, please, please, please. I thought that's where you're concluding.
So here, Kansas was found to be the state when the adoption proceedings were commenced. The mother gave the baby up for adoption on the date of birth because the prospective parents or adoptive parents were granted temporary custody shortly after the infant's birth. Kansas was not the child's home state. The court determined that Pennsylvania also was not the child's home state. Applying the statute to the present case, the child never lived in Pennsylvania with the parents or a person acting as a parent. On the record presented, the court had no basis for concluding that the child had a home state when the proceedings were commenced. So the court determined that Michigan was the child's home state because the child lived there since birth.
All right, Ms. Gloria, question for you. Kevin, without looking at your screen, and if you miss it, I am going to text Professor London right now. That's, what does the UCCJA stand for? I was over your screen, look at me.
The uniform.
Hey, but before you answer this, I want everyone to know in this class, there's a very good chance this is all name thing.
Uniform child custody.
You get my phone.
Jurisdiction, administration.
You missed the E.
Agency.
What's the E?
Enforcement agency.
You got a lot of help on that. Okay, so let me tell you guys what it stands for. The Uniform Child Custody Jurisdiction Enforcement Act. Yes, I'm texting Professor London. You guys talk about it at lunch tomorrow.
Who is that?
Oh, I thought you were in her class.
No.
Oh, okay. No, you are. All right, next case, you got 2 part of adoption cases. And they both really mean the same thing. Uniform child custody jurisdiction.
Okay, the first one is JCJ versus Heart of Adoption. In that case, the issue was whether an unwed father's parental rights should be terminated when he fails to provide financial support to the mother during her pregnancy and to the child after the child's birth. The answer is yes, because the father's conduct would be considered abandonment of the child. The father's parental rights were terminated because of his failure to financially provide for his child and to communicate with his child constitutes abandonment. An unmarried biological father has to demonstrate his commitment by providing financial support, medical care, and by establishing legal paternity rights. Here, the father only established paternity rights, and biological link does not guarantee parental rights.
There you go. We've talked about that multiple times. You can abandon. It's not about genetics, it's about time and money. I know that sounds horrible, but that's what it's about. And you got one more case?
Yeah, Heart of Adoption, Inc. versus JA. The issue
was or is in a proceeding on a petition for termination of parental rights pending adoption, may the unmarried biological father's rights in relation to the child be terminated based on the unmarried biological father's failure to properly file a claim of paternity with the Florida Putative Father Registry? The answer is yes. If the father was known, identified, or locatable, he must be given notice. Intended adoption plan, PFR affidavit if the child is younger than 6 months, and reasonable opportunity to comply, but fail to comply. The holding was that the court held that the rights of an unmarried biological father in relation to the child who is known or identified by the mother as the potential father and who is locatable by diligent search may be terminated based on his failure to file a claim with the Florida Putative Father Registry only if the father was served with notice under the statute and he failed to comply with the requirements of that subsection within the 30-day period. By construing the statute in this manner.
Okay, so this is what the case goes to though. This is kind of an important part of this whole thing when it comes to PFR. We keep saying if you're not in the PFR, you're out, okay? But if I know you exist, so I'm an attorney or I'm an adoption agency, okay? And expected mom walks in and says, I'm 6 months pregnant with Joe's baby. I gotta call Joe. I can't be like, well, he won't know about the PFR. So I'm just not gonna say nothing to him. It's on him. What this case says is, oh no, adoption agency attorney. If you know who the dad is and he's locatable, you need to serve him with a notice of intended adoption. He needs to be, he needs notice of the adoption proceedings going on, even if he's not in the PFR. If you know this guy. Now, she walks in and says, Joe's the dad. And Joe's not the dad. Some other random dude. She doesn't tell me about it, he gotta be in the PFR. She walks in and says, I don't know who the dad is. Okay, whoever the dad is needs to be in the PFR. But if she physically tells me, it's Joe, he lives at 32 Drury Lane, I need to contact him.
So just make sure I get this. So if she does not know and you look it up and you fail to know and you fail to notify that father therefore has a right in a sense to be heard, but if you do know, but then if you, I think I just messed it up.
Yeah, here's the deal. I'll make it real simple. If I know about him, I need to contact him.
Okay.
However I find out about him, I need to contact him. Yes.
Sorry, if you already addressed this question, but once a father has a TPR filed against him, can his parental rights ever be reinstated?
No. Okay, not unless he show fraud or duress, ever. He's out. Okay. Yeah, he's out forever. All right, next case. Oh, one more question.
Like you said, someone's in the PFR, you give them notice and whatnot, that, at that point, he just has notice, so he can file a paternity action while you're proceeding with the adoption, right? At that point?
Yes.
But you can still place the child.
Yeah, he's gonna lose.
How long does it take for paternity?
With all the depositions and everything else I gotta file and me going on vacation and this and that. It can take a while.
Have you ever seen someone who just does the PFR option?
Yes. Okay, not against me. Okay? But it happens all the time, actually. Like they do win those cases. The problem is the unmarried biological father, he's in the PFR, we've already placed the child, he files a paternity action, okay? He does. Great, good for him. But the problem is, and this is the real problem, and it's not because me or some other attorneys delay, like it's a joke going on vacation. But it actually takes about a year to get before a judge on a contested case. This is not easy and quick. I mean, it can take a long time because, you know, we're gonna file depositions. We're gonna file for genetic, he's gonna file for genetic testing. We're gonna have interrogatories, we're gonna have all these things are actually going to happen, and they all do take a lot of time. Maybe a year is too long, but minimum 6 months. Well, in that 6 months, this kid's already bonded with another family. And I'm not saying the guy can't win.
So the biggest factor the father has on his side is time and being heard quicker.
Yes, that's what he has to do. He has to get in. His job is to get in court as quick as he possibly can. That is 100% what he's gotta do. He's gotta get before a judge the moment he can. And it's hard though. Now, especially like the bigger counties, Orange County, Dade County, Broward, County, these counties dockets are jammed. I mean, there's no room. But you're in Polk County, yeah, you can get in here pretty quick. I mean, you know, they're not jammed as much. But you're in a big county with a lot of divorce cases, it's hard to get in front of a judge. And just because it's the biggest thing in his world and its emergency is his world, well, it's the biggest thing in an emergency in all the other cases worlds too. Everybody else is the biggest deal in their worlds too, so it's there's a line, there's an order, so, but they can win, they can, it's hard. All right, next case.
So I had KH versus Department of Children and Family. This was the one where the family was in Brazil and took a flight to Washington DC and state of Florida, and they got taken in Florida. So it was pretty much a venue issue, a jurisdiction issue of if there was jurisdiction over Florida handling the case, and there was.
Yeah, the kids in Florida, dad's in Florida, we got jurisdiction. Go back to South Carolina where you were from, and it's not our problem that you can't get back down, right? Okay, so jurisdiction issues, you step foot in the state of Florida, the kids are in Florida, even for a minute is what the case is going to. We can have jurisdiction over, now, keep in mind, UCC, JEA, all that kind of stuff, baby's just born, I mean, you know, there are other factors. But Florida has an interest in a child that's in the state. Okay, now how much interest they're gonna end up having, does another state have jurisdiction? Maybe, in this case, no. Next up.
Okay, so I had BP, BCC, and Reed.
Wow, that would be a fun one to memorize for y'all.
Courtney, can you say that again?
No, I will not. Okay, so this was a case from two underage women and adoption. So pretty much the issue was whether the circuit court lacked subject matter jurisdiction and grant the adoption because GP was not qualified to seek the step adoption. And if the adoption was void, and then the last issue was if CP was stopped from arguing against the adoption because she helped in preparing the adoption. And so the court found that there was subject matter jurisdiction, the adoption was not void, and CP did stop because you can't help prepare the adoption and then go back on it. They found the court has subject matter jurisdiction when it has the authority to hear and decide the case, and the state circuit court is superior court of general jurisdiction. Nothing is intended to be outside their jurisdiction except that which is clearly and especially appears so to me. And they also said here the court has subject matter jurisdiction as it is without question that the circuit courts have exclusive jurisdiction over all adoption matters. And they said a void judgment is so effective that it is deemed ever to have legal force and effect. The court said, in general, the doctrine of estoppel prevents a person from unfairly asserting inconsistent positions.
Here's the deal. What the case is really trying to tell us is if there's, well, it's really any domestic relations issue, but inside of adoptions, the court with jurisdiction is the circuit court, okay? And the adoption occurs in the circuit court to which the adoption agency is located, or the circuit court to which the child is located. Okay, that's where venue and jurisdiction goes, but that's really a venue thing, but jurisdiction is the circuit court. It's not the county court, it's not the southern court, not whatever court you want, it's not the people's court. Okay, it's circuit court, that's where it goes, okay? Next case.
So I had BL, AEL, the issue in this case was whether state judgment granting custody and visitation rights is jurisdictional. The one pulled from the case was the
state is not required to afford full faith and credit to a judgment rendered by a court that does not have jurisdiction over the subject matter or the relevant parties. But before a court is bound by a judgment rendered in another state, it may inquire into the jurisdictional basis of the foreign court's decree, and that jurisdictional inquiry is a limited one. If the judgment on the face appears to be a record of a court of general jurisdiction, such jurisdiction over the cause of the parties is to be presumed unless disproven by extrinsic evidence or by
Okay, so what this case is telling us is full faith and credit, okay? It's a US Constitution thing. It means we gotta accept judgments and orders from other states, okay? And we're going to accept those judgments as long as the initial court had jurisdiction. Like, okay, so yes, we will accept we'll accept any order, any judgment from any state, as long as that state had jurisdiction. So we're only accepting, so this is what actually happens, real practice stuff. It's UCC JEA things, which is the Uniform Child Custody Jurisdiction Enforcement Act. Okay, good, glad we all got that. So somebody in Kentucky gets a judge's order and the kid's been there for 2 months, not 6. That's what the UCC JEA says, okay? And our court in Florida goes, we're not going to give full faith and credit to the Kentucky order because they never had jurisdiction. That's what the case is saying, is that we only give full faith and credit if the initial court had proper jurisdiction. That's what they gotta have. And if they do, we're accepting. Maria.
I had Gwinnett. That's the one about, the court erred in terminating a natural father's parental rights, because he was incarcerated was the issue. The rule is that imprisonment combined with other factors such as parental neglect, withholding of affection, lack of financial or other support, and no contact could support a finding of abandonment. But just the fact that the father or the party is incarcerated alone does not, is not grounds for terminating parental rights.
Jail ain't enough. Jail and other factors is. That's what you need to know. So if you're in jail, if you're in prison, you did not abandon your child just because you're in prison. Now, if you haven't supported your child, you're not talking to your child, you're not writing your child letters, I don't know, whatever it is. Other factors, jail is not enough. There's gotta be other factors in play. All right, next case.
And Lassiter versus Department of Social Services, the issue in this case was whether due process requires the state to appoint counsel in a parental rights termination action to an indigent person. The court found that the parent's interests can overcome the presumption against the right to appoint counsel in appropriate cases. Since the state has an urgent interest in the welfare of the child, it shares the parent's interest in an accurate and just decision. The Constitution does not require the appointment of counsel for indigent parents in every parental status termination proceeding. The decision whether due process calls for the appointment of counsel is to be answered in the first instance by the trial court, subject to appellate review.
Okay, so it's going to indigent status and appointment of counsel. Okay, here's the thing, not every case in adoption gets counsel. TPR does. Like an actual trial for termination of parental rights, you get an attorney. But every other domestic relations issue, whether it's adoption or whatnot, does not get you an attorney, only TPR. Next up.
Yes, I have, in the interest of SNW, a child adoption miracles, the SCW and the Department of Children and Family Services. So the issue here is whether the circuit court erred in denying Adoption Miracles' motion to intervene. And another issue is whether or not the circuit court erred in setting aside the birth mother's consent to adopt. The rule here is they relied on basically Florida statute 63.082 4B, but the trial court erred in denying Adoption Miracles' request to intervene, and further they erred in setting aside the birth mother's consent without notice to the adoption. conclude that there wasn't any consent, was that the consent was obtained by fraud or duress. And the statute that they relied upon, 63082, 4B, states that a consent executed under this paragraph is valid upon execution and may be withdrawn only if the court finds that there was obtained via fraud or duress.
She signs the paper, or he signs the paper for consent, it's over. That's what the case means. Unless they were defrauded or under duress. But the whole I changed my mind? Sorry, you can't. Once you sign your consent, there is no cooling off period. It's over. Unless you were defrauded or under duress. It's the only way. Go.
The case I have is MBK versus RLK. The issue is whether an indigent person indigent parent facing involuntary termination of parental rights in an adoption proceeding has a constitutional right to appoint their child as appellate counsel. The court ruled that yes, an indigent parent has a right under both the Florida and United States Constitution to appoint a counsel in proceedings involving permanent termination of parental rights for the child.
Yep, that's it. We kind of discussed it. This put it back on point once again. Involuntary termination of parental rights. You get an attorney, yes.
For an adoption, there must be a full TPR, correct?
Yes.
Because in our child protection class, we have learned about the case where they like terminated every parental right except for the entirety of parental rights. They like went into the parental rights, terminated just about everything, left like a couple small parental.
No, you're either in or out.
But didn't file a full TPR, and they did not have a right to term.
Okay, maybe so. I don't know that case. Yeah, well, I don't know. So we won't confuse our minds with that.
I'm sorry.
For the sake of our class, involuntary termination of parental rights, you get an attorney. Everything else, you don't.
It wasn't an involuntary TPR because
it wasn't everything.
It wasn't everything.
There you go. Let's go.
All right, my case was ET versus adoption of AET.
AET?
AET.
Okay.
And this, the issue here, it was whether there was substantial competent evidence to support the findings that both parents abandoned the minor child in order to excuse their consent to an adoption. And the rule is, yes, an adoption requires the written consent of both parents to an adoption unless consent is excused by the court. A parent's consent can be excused or waived by the court upon the determination that he or she abandoned the child with clear and convincing evidence of a willful rejection of parental obligations. And the court said that both biological parents had abandoned their parental rights. Court stated that they don't need the consent of parents if there is clear and convincing evidence that they abandoned the child. And the court said that the trial court considered the clear and convincing evidence standard in judging the parents' conduct, and there was competent and substantial evidence to support the findings that the parents abandoned the child, excusing their consent for purposes of adoption.
All right, so abandonment requires clear and convincing evidence. That's what we need to know out of the case. So we don't need your consent if you've abandoned, that's number one, but we can't determine you've abandoned unless the judge finds it by clear and convincing. High standard. Okay, so the old saying goes, if he throws $1 in your yard, he has an abandonment. That's how difficult it is to abandon, or not.
So I have CG versus RC. The issue in this case is whether incarceration for a significant period of the child's life is sufficient alone to prove abandonment for purposes of terminating parental rights. The Florida statute says that it's broken up into two sections. The first section says that you have to prove certain factors to make the determination of abandonment, unless section B, if the parent is incarcerated or will be incarcerated for a significant period of the child's life, that's sufficient alone to make a determination of abandonment. And the court concluded that 13 years in the child's life when the child is 5 years old is a sufficient period of time.
So if you're incarcerated, you haven't abandoned your child. unless it's significant time of the child's life. I'm not gonna get into time period you guys said, you know, that incarceration alone doesn't mean you abandon the child unless you're gonna be in prison a significant portion of the child's life. So this one was 13 years when the kid was 5. And the father had 13 more years of incarceration. And the child's life.
So I have CG versus guardian ad litem program. The issue is whether an executed surrender and consent to adoption can be revoked if the original placement backs out of the adoption. Under Florida statute 63.0824B, consent to an adoption may be withdrawn only if the court finds it is obtained during fraud or duress. So the conclusion is an executed surrender and consent to adoption cannot be withdrawn just because the original adopted parents back out, as a withdrawal is only allowed if the court finds that the consent was obtained through fraud or duress.
Same story, just a little different facts. That's what the cases are. It's the same rule, same issue. In that case, the adoptive parents changed their mind. Well, it doesn't matter. You signed consents. So you weren't defrauded, you weren't under duress, they changed their mind.
I had WK versus the Department of Children and Families. So the issue was whether foster parents have rights to appeal a ruling to transfer the custody of the child. The rule was that participants do not have standing to appeal, only parties to a case have standing. And foster parents didn't have standing to appeal.
Very good job. Participants don't have standing, only parties do. So in that case, what it stands for is foster parents. You're just a participant. You're not a party. And they can move the children in and out of your house. Sorry, is what it is. You're a participant, not a party.
I had Stark County Bar Association be there. The issue was can failure to disclose money disbursements from potential adoptive parents and money paid to an expected mother cause disbarment. The rule was there's a list of expenses that are allowed to be paid for by the adoptive parents to an expected mother. This includes rent, transportation, medical, utilities, but every expense must be reported and disclosed to the court. And then the holding was Attorney Stark.
Yes, here's the deal. The statute tells us what you can pay for. What did the statute say? They can pay for?
Essentially transportation, utilities,
Rent, medical.
and
That's all I have.
Okay, so that statute listed 4 things. If you give the expected mother things outside of that, guess what you just committed? It's a really bad crime. It's called human trafficking. That's what you've just committed. You just bought a baby. Okay, so can you get disbarred for human trafficking?
Yeah.
Yes, you can. Okay? Yeah, that's what that is. When I say, here's $5 grand for your baby. That's human trafficking, okay? Yeah, serious stuff. When I say, yeah, if you give me your baby, I'll buy you a new car. That's human trafficking. Not good. The bar doesn't like it. Go ahead.
I have Rushing versus Boss. This case, it's surrounding misconduct by an attorney, which took the child out of the care of the parents for some time. And it's kind of complicated, but to make it short, they're kind of bringing action for malpractice based on the kid and the grandparents that lost their custody. So there's 4 holdings. The first was for legal malpractice, and basically the rule on that was that there doesn't have to be privity of contract in this case to constitute legal malpractice because there was an implied duty of care between the adopted attorney and the child. So that one stands. Malicious prosecution was the next count that they brought. And the court reversed the dismissal on the behalf of the child, but dismissed because the grandmother and great grandmother didn't have standing. So you have standing to kind of bring that claim. And then there was civil conspiracy. which they held was dismissed also because they were citing a statute where you sign things as an attorney, and they said that they're barred by immunity for that one. And then IIDD was also dismissed because they said what happened here didn't constitute intentional infliction of emotional distress. It was reckless and it was like ethically wrong, but it didn't cross the threshold.
What we need to know about this case is very simple. Is you can get sued for malpractice, okay? Even if you didn't have privity of contract with someone, okay? When it comes to adoption. So, I mean, hypo is I represent so-and-so, right? And I make a mistake and a third party is damaged by that. Example, I represent the adoptive parent. And I know about a potential biological father, and I don't give him notice. And we go through the adoption process. And he doesn't get his notice he should have got from me. And now he's suing for paternity, and it takes a year to get into court. And the judge says, you don't get your kid, because it's already bonded with this other family. I've committed malpractice against that unmarried biological father, even though he was never my client. That's what the case is going to, is that you don't have to have privity of contract to commit malpractice inside of adoption. Okay, you kind of have a duty to everybody to be ethical. We're talking about babies here. So my ethical duty extends beyond my client. My ethical duty extends to the entire process, is what it extends to. All right, Lana, you're up. You didn't have one.
I didn't have one. I had macros be Chichoki.
Yeah, Chichoki.
And so this is the case where the bond tried to get custody of the child, but the Connecticut court had granted the father full custody of the child, and the father moved to Florida, and he got a stepmother. So the issue was, did Florida lack subject jurisdiction to enter the final judgment of the step-parent adoption, because at the time the petition was filed, Florida was not the home state of the minor under the UCC JEA.
What does that stand for?
Uniform Child Custody Jurisdiction Enforcement Act.
Dang, she's ready for the exam. Y'all better watch out, Curb just got ruined.
So the rule was, whether Florida was the home state, the rule was, it doesn't matter whether Florida was the home state of the child under the UCC JEA, because the father was living in Florida with the child. And he had sole custody at the time of the step-parent, adoption was filed, and he was the only one in which consent was required. And then they also went into talking about a person who was entitled to notice, because the aunt believes that she was entitled to notice, and it says the interest that entitles the person to notice of an adoption must be direct, financial, and immediate, and the person must show that he or she will gain or lose by the direct legal operation and affect the judgment. And she did not.
Aunt gets no standing. Aunt has no standing. So dad is the only person to whom which consent is required in that case. Okay, he's the only one. And everyone else is like, well, hold on one second. He's not even in their jurisdiction, like under the UCC JEA. He just moved to Florida. The kid's been over here, blah, 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 blah. That's all well and good. They might be right. But they have no standing to bring the appeal. Who are you, Aunt? I mean, your rights aren't affected even if the court entered a judgment with improper jurisdiction, because you have no standing anywhere. See, standing's a big deal in law. I mean, like in all these areas, you just want to bring some random case. Well, you got to have standing, and you guys have taken common law, most of you. It's that whole rightness and mootness and all this kind of stuff. It actually is a real thing. And I don't want to give you like, you know, some stress based upon a bunch of taking that final very soon. That book is like 1,000 pages, but it's actually important standing. Okay. And you got to have standing. If you don't have standing, what matters? What does it matter? It doesn't matter to you whether the court erred or not. You have no skin in the game. You have no right to be there. So, sorry. Last but not least.
Farming versus the matter of an adoption. The issue here is whether an attorney is entitled to their attorney's fee if they can show that fee is reasonable. The rule is you need to show the judge an minimization of cost and time
and why your fee amount is reasonable. So long as your fees are justified, you shouldn't have a big problem with getting your fee.
That's what this goes to. Estimated fees and costs for attorneys. They gotta be reasonable in adoption. But as long as they're reasonable, the judge should grant them. Like the judge is bound by them unless he can find that they're unreasonable. And I mean, I've never had an issue. I don't know any attorneys had an issue. It's expensive to do an adoption. The judges know that. This is not a cheap thing. And I can tell you right now, all you have to do is say to the judge, well, boy, counselor, $30,000 seems like a lot of money. Well, Judge, I was at the hospital at 2 a.m. You know, I've been dealing with this expectant mother for 4 months. I've been organizing payments between the adoptive parents and the hotels and this long list of things. And they go, okay, I get it. Yes.
Do you just keep track of your hours, like billable hours to the?
Yes, we keep track of, we charge a flat fee, but we track our hours in case anyone ever asks. But we don't bill them, but they are tracked. All right, well.